Good morning, everyone. Welcome to the third webinar on NSIPs during COVID-19. Just wait a couple of minutes for people to join. Again, welcome to this third webinar on NSIPs during COVID-19. We'll just wait a minute or two for people to join before I start. Good morning and welcome to the third webinar on NSIPs during COVID-19. I'll wait one more minute before starting to allow a few more people to join. Okay, I think that's enough attendees, but obviously a few more people will continue to join and they'll just miss the beginning. So this is the third webinar I have held on how NSIPs are being progressed during this pandemic. As before, it is suitable for anyone who didn't attend the other two, or either or both of them, but also should be of interest to people who did. The last one was on the 4th of June, and there's been quite a lot of development since then, which I will go through. On my slides, the text in green is new since the last webinar, and text in black isn't. So, as it's the third one, previously I said you please be forgiving of glitches, but it's the third one, so you shouldn't be so forgiving, obviously. I hope it goes smoothly. It is meant to be interactive. Please ask questions and make comments, and I will try to answer them. So you've got two options. You've got a chat button and a Q&A button. If you could please send your questions and comments to me using the Q&A button, and send any issues, technical issues you might be having using the chat button, and my colleague Melissa will look at those. I won't, so I don't get flustered that everything's going wrong. And she will try and sort out what she can, but obviously if it's something at your end, then there's not much we can do. So you may have to just end the call and come back again, or try that or something like that. So this webinar is, although it's evolved since the first one, it is based on a paper I produced, which when you get these slides, you'll be able to click on that link and get straight to it, which in itself is based on a much longer one produced by the National Infrastructure Planning Association. on all the various areas that need attention during this pandemic if things are to continue. So you will get, you should get these slides, my written answers to the questions you have asked and comments you have made, and even this recorded on YouTube in due course. So you don't need to make notes or anything. It should all be done for you. So what are the topics that I'm going to cover? All the different areas in the lifetime of a project that are potentially having problems because of this pandemic. So documentation that can't be deposited or inspected, site notices that can't be erected or seen, even if they were erected, land referencing that might not be able to be carried out, site surveys that can't be carried out or wouldn't be representative, consultation events that can't be held in person, hearings and site inspections that can't be held in person, and granted DCOs that can't be implemented. And there have been developments on almost all of these since the last webinar on the 4th of June. So stay tuned. Right, we'll do these in order. If you hear a rumbling noise in the background, I put my dishwasher on an hour and a half ago and it's still going. I'm sorry about that. So first topic, document, deposit and site notices. There is a legal requirement for documents to be deposited for inspection. And although I suppose you could argue it doesn't say that it has to be physical deposit, it certainly is implied because it talks about things like being in the vicinity of the project, and the internet is everywhere. So that sort of doesn't make sense. But then again, the internet is also in the vicinity of a project at all times. So here are some examples of where it is required. During the statutory consultation, the statement of community consultation must be made available. When you've applied for your DCO, and you must deposit documents upon when it's accepted during the representation period. Then you have to certify that you did that thing. If you amend compulsory acquisition powers during an examination, you need to deposit the amended documents. Site notices of hearings need to be erected, although that's the one example where the examining authority can actually waive that requirement. Then once the DCO is granted, you need to put up site notice and deposit documents for compulsory acquisition purposes. And finally, if you're going through the material or non-material amendments, similar considerations apply. So where are we? Well, I've kept this slide in, no change to DCO legislation yet, but there has now been a written ministerial statement last Thursday, 25th of June, which said that the legislation will be changed on this topic shortly. However, it won't apply to site notices, which will still have to be erected. I guess there's less of a problem with doing that, although query whether anyone will see any of these site notices because they're unlikely to be going past them, but there we are. So all the references in secondary legislation, so that's all the regulations, rules, etc. that sit below the Planning Act 2008, they are going to be changed shortly, in quotes. That's the word that's used, so that online only deposit will be okay. And that will apparently be a temporary change. I'm not sure whether they'll give an end date or they will tie it to some sort of declaration of the pandemic. Given that the House rises for the summer recess on the 21st of July, one would hope that shortly would mean by then, which is less than 3 weeks now. However, there are two references in the Planning Act 2008 itself, referring to physical document deposit. One is in section 47 in relation to the statement of community consultation, and the other is in section 134 in relation to compulsory acquisition. Once the DCO has been made, that will not be changed. And instead, one will have to rely on the text of the written ministerial statement of last Thursday, the relevant portion of which I reproduce below. It is the government's view that these requirements, i.e. just those two, can be met by making documents available for inspection online. It expects applicants to take reasonable steps to ensure that anyone wishing to view the documentation can find these documents online. A little important rider, hard copies should be made available by the applicant on request. So it's not purely online only. What the recommendation is, if somebody asks for a hard copy, and that should probably be, they should be able to ask via phone as well as email, given that some people may not have internet access, then you should provide them with hard copies of these two things. However, all other things will in due course be changed. I would just comment that I think the reason for the distinction is not because there's anything different about those two deposits compared with the other ones in their nature. It is just that they are in the Planning Act rather than in secondary legislation, and so more difficult to change. Even though there is a business and planning bill that could have been used, that is currently before Parliament, but there we are. That is the situation. So in practice, consultations have been extended but are continuing, and there's an example of a section 48 notice you can look at. On that point about waiving site notices of hearings, one of our projects, M25 Junction 10 for Highways England, we asked for that waiver. The examining authority did agree, but did ask that an additional newspaper notice be placed in compensation. And that's very typical of all these things, that on both these counts about longer consultations and compensating activities, that usually things will take a bit longer. You will have to do more of other things to compensate for not being able to do the physical ones, but in general you can continue. The South Humber Bank project has started its representation period, wholly in lockdown. There's a link to the section 56 notice. It's 7 weeks long, so that's probably a bit longer than it would have otherwise been. It allows you to borrow hard copies of the application on request, or an e-reader containing them. Very trusting of the applicant there. And although deposit locations, the typical ones of libraries, are documents aren't being deposited there, there are still 2 deposit locations at the site of the project and at the developer's headquarters. So those are much more in control of the developer, and they're only by appointment. So that might be something for others to follow. Actually, I haven't put it on the slide, but there's an issue with libraries opening possibly even as soon as this Saturday, the 4th of July. So if they're opening in the middle of your some period you've set, does that mean you then have to start depositing them? I would have thought not. So I'll just have a look at the Q&A. I've got a couple. First, it's obvious that some legal advisors and their clients are very well set up in terms of webcams, etc., for virtual hearings by MS Teams. At the EA, that's the Environment Agency, rather than the Examining Authority, we can only use MS Teams on our iPhones. Are virtual hearings going to disadvantage statutory consultees and other third parties who are not so well technologically resourced more than the normal kind? Carol Bolt. Thank you, Carol. I will try and remember to answer that in a minute when I get to hearings. Not that I'm criticizing you for asking your question now, that's fine. Anyone can ask anything at any time. Next one, can you charge for hard copies given that they are not available in public places? Well, that is a good question. You can, I suppose, you can try, but it's a judgment call really. Are you providing sufficient opportunity for people to see your application by other means, because hard copies of a whole application, for example, might be very expensive to produce, and they're normally charged at cost or similar, something like £500, and that's not going to be very feasible for most people. In fact, the people who don't have internet access are least likely to be able to afford such a huge amount. So I would think some sort of compromise must be necessary. So for example, maybe one hard copy could be free and any further ones you could charge for, or you could provide a summary document that's free, or you could lend the hard copy or something like that. But charging a huge amount for hard copies when that's the only way someone without internet access would have of finding them is probably not going to be the best idea. Maybe a nominal fee, but even that's a very good question. And one more. Where interested parties who do not have access to or are not confident using electronic communication be entitled to have facilities support provided by the local planning authority at their offices to ensure that they can make appropriate comments, representations. Well, I wouldn't use the word entitled, but that would be an option. I mean, having facilities and support is really the onus on providing those would be on the applicant, the developer, although they could reach some sort of agreement with the local planning authority if their offices are open. Certainly planning authority websites are being used to host things, but that is something between the planning authority, if it's willing to do that, and the developer. There's certainly no entitlement for that, but it's something that a developer could explore with the local authority. Right, that's all I've got at the moment. So I will move on. Will I? Yes. Oh, I had one more slide on document deposit. So this is in the NIPA paper and my summary. We were recommending a change in the law to avoid the risks of not depositing things when you really should physically. There was a statement on the 13th of May that was general, a statement on the 27th of May that only applied to CPOs, but now we've got the one on 25th of June. So I think we do have what we need in this regard, although personally it would have been better if the two Planning Act 2008 references were also amended. But I suppose it is more difficult, even though there's an act, a bill going through Parliament, when you need primary legislation perhaps, unless it was time limited, to revert back to the normal situation. And if you time limited, you might get that wrong and the pandemic's still going or well over by the time you've stated. So sorry, I'm looking at the Q&A again, just as it's telling me there was another one, but there wasn't. It's just I hadn't dismissed the other ones. But this is what we're going to get. So that's the situation. Moving on to land referencing. No change here. The standard in the Planning Act is diligent inquiry. So it doesn't specify what exactly you have to do to reach that standard. However, in practice, that normally involves leafleting people, knocking on their doors, the people who have unregistered land or land that you need further information about, can't find on the land registry, or need assurance that it's correct on the land registry. So the solution is to step up other activities, such as other ways of contacting people. If you can find phone numbers, email addresses, you can probably still put leaflets through people's doors or even knock on people's doors if you take appropriate precautions. But this may mean that the whole process takes a bit longer. So there's no change in the law needed. If there had been reassurances of that practices would be satisfactory, that would be reassuring, but I suspect we're not going to get anything on that. So it's really down to developers to make a judgment call on that issue. See if I've got any Q&A. No. Site surveys. Now, this is probably the most interesting issue of all, because it's something that can't really be solved through legislation, unless you're going to water down environmental impact assessment, and that's never going to happen. So the two issues are, so this is surveying your site in order to carry out your environmental impact assessment. You obviously need to take readings of noise and air quality and such like to establish what the baseline is on which your project is being added to see if there is a significant impact. But you may have difficulty accessing a site at the moment, and even if you could measure these things, it's probably going to be unrepresentative because of there being much less activity, particularly traffic around. So therefore you may, if you took the readings as they are now, you added your project on top, it may look as if it's not significant because it's below any congestion on the road network or air quality limits or whatever. But in real life, if there is ever real life afterwards, then it would in fact probably be significant, could well be significant. And I make a distinction here between ordinary, if you like, environmental impact assessment and ones where there is a sort of absolute standard, namely habitats, air quality, water quality. There are some others. But for example, air quality has an absolute requirement that the pollutant NO2 can't exceed 40 milligrams per cubic meter. And even if, however wonderful your project is, it won't compensate for that. It's not a balance between its benefits and its adverse impacts, whereas general EIA is a balance. So just bearing those in mind is a special example, special cases. So in terms of being able to carry out the surveys in the first place, that's quite old letter now, but DEFRA wrote to CIEEN, or the IEEN, and said you should be able to do it. So there you are. So the difficulty is really the unrepresentativeness of the readings. And as I said on the previous webinar, the first glimmer of any coverage of this issue by the Planning Inspectorate was in a scoping opinion that they issued in late May, I think. And they have now reflected this in Advice Note 7 on environmental impact assessment. So I've given the text there. I mean, it doesn't really give you any solutions, but it recognizes that there is an issue and says that you should work with bodies like Natural England, other stakeholders, and the inspectorate will adopt a flexible approach. But obviously you do need to carry out, and you still need to carry out a rigorous environmental impact assessment. So as I've suggested previously, there is this reasonable worst case approach. And there's the example of HS2. So this isn't new for the pandemic. It's been around for a while as an option for where you haven't been able to access land at all, or not at all for anything, but at all for some particular assessment topic maybe, or only limited access. So the approach is assume the worst, or a reasonable worst, that if you're doing you can't do a bat survey, assume that the reasonable worst number of bats that could possibly be on that land are there, and propose mitigation accordingly. And there are downsides to that approach. One being that you will therefore probably end up proposing mitigation and perhaps having to earmark land for such mitigation that is very unlikely to be needed. That could give problems with compulsory acquisition, and you're having to do more than you really will have to do if you had been able to count the number of bats, there may hardly be any, or none even, but you're going to have to provide mitigation. Second point is that it's reasonable worst case, not the absolute worst case. Not as if there's a bat on every blade of grass that they could possibly cram onto. So you will probably in your DCO still have to deal with the possibility of the actual situation being even worse than your reasonable worst case. Something like you'll have to stop construction or operation or whatever until you have proposed further mitigation. This has been accepted, or something. So the mitigation itself will have to be more flexible. It'll have to be more of a scale rather than an absolute commitment, depending on what the land actually yields in terms of measurements. And this can't be used if you haven't been able to do anything, I would have thought. Although theoretically you could say the worst case for every single topic and not even look at the land at all, but I think that would not be an acceptable approach. So there needs to be more cheese than holes in your environmental assessment, really. And those absolute criteria will probably need more attention because they're so sensitive that you may not be able to just make assumptions, but may need to have readings on some of these topics because of their sensitivity. Right, I've got a couple of new questions. With lockdown restrictions easing, do you see there being a move back towards normal conditions and hence surveys being expected to be carried out? Well, one would hope so. And actually, I think it's going to be more complicated than a linear easing. I think there's going to be, as there already are, local and clamped down lockdowns being reimposed, or even a national one. I must say I'm very, very worried about pubs opening on a Saturday of all days of the week, this Saturday. Given experiences elsewhere, like in the US, where public gatherings indoors have been caused a big increase in cases. But anyway, that's another story. So if one was able to carry out the surveys during any period, then you can't say in your environmental statement we weren't able to, so we had to do this reasonable worst case. So yes, it's going to have to be pretty adaptive. So you may be able to start doing the surveys and then have to stop again. So that might be a particular season you can't do, but you could do another season. It's all going to be a bit messy if you want to keep your project going, but you'll just have to go with the flow and do the surveys when you can and cope with them in other ways if you can't. Right, one more question. Are applicants meant to have specific health and safety working practices where entering land which is occupied by people? I'm thinking of operational sites belonging to water companies. That's probably because you work for a water company, Stuart. Well, indeed, the health conditions override everything in all of what I said, and thank you for reminding me to say that. That in particular interacting with people, I mean, most surveys are on land that is unoccupied because you're going to build your project hopefully on unoccupied land, but not always. There may be bits of it that are occupied, or even all of it, if you're replacing something. But you will have to adhere to best practice in health and safety in any pandemic guidance on top of that, and definitely that all takes priority before you start marching onto sites and taking measurements. Right, next topic. Go away, Q&A. Our consultation events. So the document deposit side of consultation I've already covered, but this is the bit about actually holding what you would normally have done is physical events where people can turn up and talk to people working on the project and ask them questions. So it's still true that no project has done a full statutory consultation during the start of lockdown. The Lower Thames Crossing held its last 2 events online, but it had held something like 11 out of 13 of them in person. And I mentioned the approach to documentation. Of interest since the last webinar, a forthcoming application, the A428 Black Cat to Caxton Gibbet, is holding a non-statutory note, supplementary note again, so it's already done a statutory consultation, but it's holding a non-statutory one, has now started. There's a link to the relevant section 48 notice. And what they're proposing are 2 webinars and 2 phone-ins. So because it's a supplementary consultation, that's probably smaller than the whole project, and that's why there's only 2 of each of those things. But those are definitely ideas that others could adopt. Phone-ins I can see as a good idea because of the lack of internet access that some people may have. The London Resort project I mentioned before is planning a statutory consultation in July, towards the end of this month now. So watch this space for how that covers physical and equivalent to physical events. So as I said before, there's no green on this slide, and it's now unlikely that a previously issued SOC could still be operative, I suppose, because that would be back in February. So you may need to reissue your SOC if it talks about physical events. You need to compensate your non-contact activities to achieve at least the same standard and reach the same and have the same reach of people as physical events. And that's one area, as I say, that may be able to be improved because people may be unable to attend physical events, and you might not have given them that much attention, the attention that they probably ought to have had, but now you're having to, so they may have greater opportunities to participate in a consultation. Consultation professionals, the usual companies, are developing and have developed now online systems equivalent to, well, not exactly equivalent, but near as equivalent as they can manage it to physical events. So give them a job to do. And you're going to have to consult a whole list of statutory bodies as usual, and it's a very good idea to check in advance how to contact them, because they may have staff furloughed, their offices may be closed, their usual email addresses may not be being read. So definitely a good idea to find that out before you embark on your consultation. So there's no absolute requirement in the law to have physical events. It's all down to what you say in your SOC. So there's no change in the law needed on this one. A statement that these events should be able to continue online would help, but it looks as though we're not going to get one of those. Okay, I've got one more question. Could you draw up a SOC which provides for both possibilities, in-person and virtual events, or would you need to be specific? Well, I think as we move out of lockdown, these SOCs may have to become more flexible. However, you're also going to have to consult local authorities, as you must with a SOC, on what you're doing. So you can't just say, well, we might do some physical events and we might do some virtual events. I think you're going to have to be perhaps specific on the numbers of each of those that you would do, and it'll be some combination of the two. I'm thinking of the threshold for a port nationally significant infrastructure project, of all things, where look up the relevant section of the Planning Act, where it says a port expansion or a new port is an NSIP if it has a certain number of container handling facilities increase, or a certain number of roll-on, roll-off movements, or a combination of those two, like half the containers and half the roll-on, so that it adds up to a limit. So say you're going to have, if it was all events, you're going to have 10 events, and if it was all online, you're going to have all 10 online webinars. Then you might say we'll have a total of 10, but depending on lockdown conditions, we will hold online ones or physical ones, something like that. I'm really thinking off the top of my head, as you can tell, but you can't just be completely vague in your SOC as to which type you're going to have, or how many you're going to have rather, but you may need to be flexible as to which types you're going to have. Good question. Right, moving on. Hearings. So in a sense, it's not for applicants to worry about, it's for the planning inspectorate to worry about. But you'll certainly, as an applicant or a third party, you'll need to keep up to date on what's going on. So first point to note is that hearings and preliminary meetings may be spread, and indeed now have been spread, over longer periods. And it has caused some examinations to be extended. Although I know the planning inspectorate is keen that examinations that either have only just started or are about to start shouldn't be extended, and the hearings should be accommodated within the 6 months. But the initial ones were extended. So since the previous webinar, there hadn't been any online hearings, but they now have. And they went very well, I am told. Hurrah. So the 2 projects that had them, in fact, and 3, the third one is having some now. And a 4th is having one today. So it's all go on the hearing front. One tip that I could mention that's caused problems is complex PDFs or other documents being displayed, because remember that people won't have necessarily very fast internet connections, even if they're able to participate. And if you have a very weighty PDF with lots of layers, you don't want to hold up the whole hearing while it sort of slowly draws all the different layers onto the screen. So if those could be replaced for the purposes of a hearing with a single image, there's just one layer, then that is what PINs are requesting. Another tip for applicants and other multi-person parties who have people in different locations is you will need your own way of communicating with each other on top of the hearing system. They're using MS Teams on the hearing. I'm not sure if they're going to be able to use, or they have started using side rooms on Teams, but that might be an option on the main hearing. But there are other ways. You can use Zoom for your own one, or WhatsApp or something. But you are going to need a way of communicating with yourselves that doesn't get publicized to everyone, and a good idea to practice that before you have the actual hearing. So I've mentioned that examinations will end up not having to be extended. And it's already instructive that the first one, A38, was extended for 5 months, but the second one was only extended for about 6 weeks, I think. M25 Junction 10, and that finishes next week. Well, a week on Sunday, actually, 12th of July. So things are already getting back to normal in extension terms. So that's good news. The Kemsley examination is interestingly trying to have no hearings. So that may survive or may not, because people can cause hearings to be held by asking for them, open floor and compulsory acquisition hearings, whereas issue-specific hearings are within the discretion of the examining authority. When it comes to preliminary meetings, we still haven't had an online preliminary meeting yet, or even a date for one in the future. And I think, not surprisingly, the Planning Inspectorate were waiting for the hearings to take place to see if they worked before embarking on the preliminary meeting online. But now that some of those have been held and they were successful, that will be the next thing to happen, I think. That is probably the last piece in the jigsaw, if you like, or the link in the chain between the start and end of an application that has not yet been fully dealt with, but so we await that with interest. The Aquind project is probably going to be the first one, but there are a couple of East Anglia offshore wind farm projects as well. That those three all had a physical preliminary meeting date that had to be withdrawn because of the lockdown starting. So they're the most advanced. So watch those web pages for news on that. Finally, on site inspections, sorry for the jargon, there are still not going to be any accompanied site inspections, but to compensate, there are being more unaccompanied site inspections. So that's where just the examining authority go out on the site. So I think that'll probably continue. No more accompanied ones, but more opportunities to suggest what should be inspected by the inspectors, and they will go out and do it more frequently. Right, now I'll finally address Carol's question about lack of parity of technological ability. Are virtual hearings going to disadvantage statutory consultees and other third parties who are not so well technologically resourced? Well, one would hope not, but it may be the case. If you do have concerns, if you've attended a hearing and you didn't feel you had, you were able to participate as much as you would at a physical hearing, then please definitely and urgently let the Planning Inspectorate know. But they are trying very hard. I pay tribute to them for what they've achieved in a fairly short space of time, trying very hard to give as much access to people as they would have had at a physical hearing. I was asked last time, I might as well make the point again, that you do have to make yourself known if you are going to attend a virtual hearing so that you can get the details of it. And that is a difference with physical hearings, because with a physical hearing, you can just read where it's going to take place and turn up on the day, and nobody need know that you are going to do that. Whereas to find an MS Teams link, that's not going to be published for the world to see, because that will cause, I suspect that would cause problems with malicious people trying to disrupt hearings who have nothing to do with the project. So you will need to ask to be sent the link to the meeting. So that is a step, an extra step you need to do because it's virtual. There were various problems with local authorities who tried to hold initial meetings back at the beginning of the lockdown by publicising the link for all to see, and that went a bit wrong, so I don't think that's going to be adopted. So Carol, good question, but everyone is trying very hard not to disadvantage statutory consultees or anyone who is going to be less well resourced than an applicant or the Planning Inspectorate itself, and so on. Right, no more questions for the moment. So moving on to implementation. Development must be, it's fairly standard to have this as a article in your DCO. Development must be commenced within 5 years of the date of the DCO coming into force or being made. So some projects that didn't have to deal with the pandemic at the time they were being consented back in 2015 are nearing that or have indeed passed that 5-year deadline. Compulsory acquisition also must be undertaken within a certain period, often the same 5 years. and that may be affected, although at least it doesn't whereas starting development does require physically going onto the land and doing some development that is sufficient to count as having started. Compulsory acquisition is generally not a physical activity. However, it's often tied, getting the money to pay for the compulsory acquisition of land is often tied to starting the development, so it may also be held up. Whereas the Business and Planning Bill, which completed all its stages in the House of Commons yesterday, sorry, on Monday, not yesterday, is now going to be in the House of Lords next week, so it's really being expedited. That is extending ordinary town and country planning permissions that would have expired from the point that the planning bill becomes an act and that section comes into force, and the end of this year. They're all being extended en masse until the 1st of April next year. And for ones that had already expired between the beginning of lockdown and the date the section comes into force, they will also be extended, but you must apply because of environmental impact and habitats considerations. They will be extended if there's no impact on those. That's happening. Unfortunately, the same is not going to happen for DCOs. You might think that, well, you've got this bill for TCPA permissions. Why can't the same be done for DCOs? Well, I've thought about this a bit, and while I initially had the same attitude as, why don't you actually amend the law to allow virtual document inspection in the 2 cases that are in the Planning Act? Why don't you do the same for DCOs that are about to expire? There is actually an issue here, a legal issue, that, and this is the obscure area of hybridity of legislation. You might be aware that the HS2 bills currently going through Parliament and its predecessors and Crossrail and so on were all hybrid bills, and these are because they especially affect a small group of people rather than the general population, namely the people in the line of the routes of those projects. And there's a whole extra process in Parliament where those people can make petitions and appear before a committee of MPs and peers and so on. Now, if there was a blanket extension to DCOs, which in fact only affected 2 or 3 DCOs, then people affected by those DCOs would be arguably especially and directly affected. And the whole business and planning bill might turn into a hybrid bill and have to go through all that extra process that takes ages. And so I can see that's why they're not doing it. And so I'm afraid if you have a DCO that is about to or has expired, you're going to have to go through the usual non-material, or it might even be a material amendment to extend your DCO, which is going to cost you time and money. But you have had 5 years to implement your DCO, and you don't have to do very much to implement it. But I sympathise, because it could be tied in with some sort of government grant or saving or something else external that means you haven't been able to implement your DCO. But there we are. The government is not going to extend the time for you. You're going to have to do it yourself. I've got one more question, which is on, I've always thought the DCO was predominantly a written process, and therefore no one should be disadvantaged as long as they make their views known in writing. It is indeed predominantly a written process, which is why probably it's been able to continue largely unaffected. However, there are exceptions, particularly in the field of compulsory acquisition. Given the human rights considerations of someone having their land taken away from them, that is why the Act allows someone who is in that situation to cause a physical hearing, or a hearing at least, to take place, so that they can challenge in person the rights being sought by the developer to take their land. So yes, it is predominantly written, but there are some cases where being able to have an interaction with the inspectors and the developer and the applicant is important. And even on specific issues, while it may be possible to avoid having hearings, there are some issues that where, if you look at the criteria in section 90 something of the Act, why there might be a need for an issue-specific hearing, like why there might be a need for cross-examination, for example. There are occasionally those needs. So there are exceptions to the predominantly written process. Right, no more questions. I think we're nearly at the end. Right. Now, I've recently learned through attending another webinar on Zoom that you can have a poll on your Zoom. Isn't that exciting? So I'm going to have one. Now, I need Melissa to set it up. Here we are. I hope you can see that. Here's my question. Has the government done enough to allow NSIPs to progress during the pandemic? You have three options: yes, no, or not sure. So please, if you can see that screen, please choose one of the options. Oh, it says at the bottom, hosts and panelists cannot vote. All right, I'm disenfranchised. So we'll wait a minute or two while you answer that. I think I've got another question, which I'll answer while you're conducting the poll. You're thinking of what to do for your poll. Here we go. What would happen if you commenced construction on your DCO to implement within the 5 years, but you hadn't necessarily discharged all the relevant conditions? Well, if you've commenced construction in breach of the conditions that say you must fulfill them before you can commence construction, then that wouldn't count as commencing construction. There's various case law on that. But if you are able, A, to commence construction properly, and B, to discharge at least enough of the conditions to allow you to do that legally, then that would count as commencing construction. A DCO tends to have a few activities that are exempt from commencement, so pre-commencement, so they wouldn't count if you just did those, because by the terms of your own DCO, you haven't commenced. So you would normally have to have discharged all the conditions that say no part of the development can commence until blah. But you can often divide your project into parts and then just discharge the conditions relating to a certain part and then start that part, and then you've started the whole thing. So that's one way around it. One more. What works, let's publish that. What works could commence ahead of DCO being granted just using GPDR? Would that affect the final decision? Well, that's a big question. That is generally asked, never mind the pandemic. Developers who have permitted development rights can sometimes do some things already, even before they get their DCO. But I would have thought they would have to be reversible so that you can put them back if you don't get your DCO. And you'd have to be very careful that they were able to be exercised under the terms of the permitted development regulations rules without the corresponding main permission and that sort of thing. So I can't really give you an answer off the top of my head. That would need proper legal advice. But indeed there are, if you applied for a planning permission, for example, to do something that was in advance of getting the DCO and you were granted that, you could implement that, but it obviously wouldn't count as the DCO being commenced because it was a separate permission. Right, no open questions. So let's Melissa, shall we close the poll and see what the result is? Drum roll, please. Has the government done enough? Okay, by a slim margin, it's 52 to 48, is it? 52% say yes, the government has done enough. And I would include the planning inspectorate in that. So well done, government. On a very unscientific poll, you have probably done enough to allow NSIPs to progress. However, there are a number of people who are not sure and a number of people who say, no, you haven't done enough. So if anyone would like to email me, perhaps after this webinar, of suggestions of what more could be done, I'd be very interested to hear that. I'll put a post on LinkedIn and for a conversation as well. So let the conversation continue. Oh, that was interesting. Right. So I've got 5 minutes left. Does anyone have any more questions or comments before I close the webinar? Actually, one of my colleagues has put on the chat, which I've just decided to look at, a comment, which I'll just read in case it was just private to me. Oh, yes, okay. So this was before the pandemic, but on one of our Highways England projects, we invited people who had difficulty making representations or were not comfortable doing so, and to ask the developer, the applicant, to air those representations on its behalf. So if you didn't mind doing that, then that's one option. Or indeed, perhaps you could ask the examining authority that the questions are put orally to the team, but you didn't have the wherewithal or the confidence or the ability or the internet connection to do it yourself. So that might be an option. Don't email the examining authority directly, but the case officer, of course. But that might be an option. And I'm saying that off the top of my head, and I don't know whether PINs would generally allow that, but that could be explored. Thank you. Right. Okay, there being no more questions and answers, thank you very much for attending. I will probably do another one in about a month's time, because hopefully for example, the document deposit legislation should be before us by then. The business and planning bill should be enacted. That may or may not affect DCOs. Oh, I've got one more question. Thanks. Okay, thank you. That was a comment. So thank you, everyone. I hope you've continued to find that interesting. If you do have any further questions, let me know by email, either through the events email, or if you've got my own email, it's on our firm website, or we can have a discussion on LinkedIn. I'm very grateful for your participation and your questions. Thank you very much, and good day.